I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. I was attacked by some people, and I was protecting
Sir,
my life.
I know you
One
don't
Okay.
want
second,
my
ma'am. One
representation, but
second. No, ma'am. No, ma'am. No, ma'am. No,
I would
ma'am. Please
advise that
don't.
you not
Please
talk about
don't.
anything that happened.
Please don't. I have reiterated that Latavius Treshaw Thornton is a nonprofit organization. I am not a surety. I am shoulders.
Do you have a medical marijuana card?
Mr. Thornton does not know.
Was the GPS ordered if he was released?
That's not.
A man recently appeared in court facing serious charges, including assaulting 3 police officers. But instead of addressing the situation with any real legal defense, he claimed his name was actually the name of a nonprofit organization. He insisted he wasn't subject to the court's authority and continued talking nonstop, refusing to let the judge speak. Honestly, I'm not sure whether he truly believes this, or if something else is going on, but it was difficult to watch. Let's take a closer look at what happened and how the judge handled it. People who identify as sovereign citizens often act like the courtroom rules don't apply to them. They talk over judges, ignore basic procedures, and behave like they're on a
Public defender, Your Honor, I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
Okay. And Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shoulders. I am here as legal representation for Latavius Treshaw Thornton, which is the nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like that's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn. Okay. But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable. Okay.
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir.
Mr. A?
Mr. Thornton. So if you want to appeal,
I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavius Treshaw Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay. But yes, there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton. So, I mean, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Thornton. So I want to make sure that we treat you with as much respect. Here's why we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. No, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then We're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail.
Can I please?
Because here's the thing. I don't want to be disrespectful to you.
Right, absolutely.
I know it feels disrespectful, but here's what.
Personal mission. In this case, the judge was clearly trying to keep the hearing on track, but the man kept interrupting with off-topic statements. There's a time and place to speak in court, and when people ignore that, things can quickly fall apart, especially during remote hearings. Some individuals treat Zoom court like a casual video call, forgetting it's a legal proceeding. At one point, the man even introduced himself using an unusual nickname, saying, "My name is Shoulders." The court, of course, goes by a person's legal name, not whatever name someone decides to use on the spot. It's not a performance, it's a courtroom, and the judge has a responsibility to maintain order.
I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, if you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm fine with you doing most of it. But please, to protect my free speech, could you please not mute me? I have no intentions of disrespecting your courtroom. If I speak out of turn, could you just simply let me know? And
okay.
I am aware that I am innocent until proven guilty, and that something I say could, like you said, come back and haunt me. I'm well aware of that for Latavius Treshaw Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent, unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. And now I'm going to read the charges against you because you have a right to know them. Okay? You can't really defend yourself unless you know what you're accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for. No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before you get to reading, can I make one statement, please?
Well,
Your Honor?
You can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor. And that is why I feel it necessary for me to make certain things known for Latavius Treshaw Thornton, for that the script so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of Latavius Treshaw Thornton to the courts. That's I have those full intentions. And so that you guys can be safe from all liability of Latavius Treshaw Thornton as his representation. That is the only reason why I speak in the way of please refrain from calling me Mr. Thornton and certain things, because it's pertinent for you guys to know I've already been treated as the surety. I am not the surety. I'm really shoulders. Like, if you guys meet my people, you will find out I'm really shoulders. Latavius Treshaw Thornton is really a nonprofit organization, and I am not a surety for it. And it is a company, and it does not profit. So with that information, I understand that the script goes a little different, and I understand that. I understand me now, I have the right to let it be known that I'm not the surety, and nobody has I'm sorry, and
okay. All right,
yes,
so
ma'am.
here's
Your Honor.
here's
I'm
the
sorry.
thing. That's okay. That's not an issue.
To many watching, it seemed like the judge was far too patient. Despite repeated interruptions, the judge gave him space to speak, even when it was clear nothing relevant was being said. The man also seemed confused about how court works. Rather than speaking with a lawyer or preparing a real defense, he rambled through unsupported claims, acting as if saying them loudly would make them true. In situations like this, having legal representation is essential, especially for serious charges like assaulting officers. It's always frustrating to see someone refuse help, especially when their behavior could worsen their situation. There's a fine line between misunderstanding the system and completely rejecting reality. At one point, the man volunteered that he wasn't a flight risk, something no one had even asked him about yet. That alone can raise...
In count one, you are accused of police officer assaulting, resisting, and obstructing. And the specific allegation is that on or about March 9th, 2025, at Carey Street and Lake Lansing Road in the city of Lansing, zip code 48912, you did assault, batter, wound, resist, obstruct, oppose, or endanger Kayla Bevere, a police officer with the East Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties, contrary to Michigan law MCL 750.81D1. This is a felony punishable by up to 2 years in prison and/or $2,000 in fines. In count two, you are accused of assaulting, resisting, or obstructing a police officer, again, on or about March 9th, 2025, at Carey Street and Lake Lansing in the city of Lansing, zip code 48912. Specific allegation is that you did assault, batter, wound, resist, obstruct, oppose, or endanger Chris Shattuck, a police officer with the East Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties, contrary to Michigan law MCL 750.81D1. This is, again, a felony punishable by up to 2 years in prison and/or $2,000 in fines. Lastly, in count three, you are accused of, again, assaulting, resisting, or obstructing a police officer. And the specific allegation is that on or about March 9, 2025, at Carey Street and Lake Lansing Road in the city of Lansing, zip code 48912, you did assault, batter, wound, resist, obstruct, oppose, or endanger Colin Lemire, a police officer with the East Lansing Police Department, that you knew or had reason to know was performing his or her duties, contrary to MCL 750.81D1. This is, again, a felony punishable by up to 2 years in prison and/or $2,000 in fines. Now, how do you wish to plead?
I don't. You said a lot, so can I address them part for part first?
No, not right now. So here's what I'm gonna do. Here's what I'm gonna enter. I'm gonna enter a not guilty plea on your behalf, and here's why.
Can I ask you this first? Before you enter that plea? If me giving you a plea right now, will that be in response to everything that you just said?
Nope. So a plea would have you pleading. Would have you pleading guilty to all those charges. We've got some back and forth here. It kind of sounds like we're underwater. So a plea would have you pleading guilty to those crimes 3 felonies without having seen the evidence against you. So you can stand mute and the court enters a not guilty plea, or you can say you want to plead not guilty and you would be not guilty. Then what happens next, and here's why, then you have a chance to get the evidence against you and to consider it, among other things.
It's a bit more to it, Your Honor. That's the issue. So based off of the things that you stated, that's not what my understanding is. From my understanding is I was attacked by some people.
His concerns in court, as it sometimes suggests someone is trying to deflect attention away from other issues. Given the seriousness of the charges, it's understandable that the court would be cautious. When you step back, it's hard to understand how someone could think claiming to be a corporation or a non-profit makes them immune to the law. These arguments don't hold up in court. They never have. What's even more puzzling is that some people seem convinced this is a winning strategy. It's hard not to wonder what's going on in someone's mind when they believe this kind of reasoning will work. It's both confusing and concerning. Eventually, the judge set bail at $10,000, which was probably the right call. Given the charges and the defendant's behavior, the court had to take public safety into account. And to be honest, if the outcome had been more lenient, many people would have been left questioning the entire process. If this man doesn't change course soon, he could be looking at a couple of years behind bars. The court doesn't take assaulting officers lightly, and the way he's handling things isn't doing him any favors. We'll see what happens next, but it's safe to say this isn't over yet. If you want to follow this case, I'll be sharing updates as they happen.
I told her something that I might say could come back to haunt me. I'm already aware of that. So thank you so much, Miss Melissa, but please do not intervene. Once again, back to you, Your Honor. From my understanding, I was assaulted, and I am shoulders. Once again, I have never told anyone. Wait, I don't want you to mute me, Judge. This is going back to this situation. Okay, thank you. I never told anyone that I am Latavius Treshaw Thornton. Not one time. I have reiterated. I am shoulders, Latavius Treshaw. Not just to you, Your Honor. That's so to be redundant for the record. Okay. I have reiterated that Latavius Treshaw Thornton is a nonprofit organization. I am not a surety. I am shoulders. I am appointed to be an administrator for Latavius Treshaw Thornton. No, that's why I'm here, but not a surety for Latavius Treshaw Thornton. Furthermore, Your Honor, my understanding is I was attacked and assaulted, and I'm not sure if I could let that be known to you so that we can make that case come about, because I would like to seek forward that using the evidence from this, all the evidence that they have gathered. I would like to use it in my assault case against East Lansing Police Department and its agencies.
Now, next up, we have some dates when you're going to return to court. And let me just pull those up here. Okay, okay, go ahead.
Yes, I just wanted to speak on my previous court history and let you know why it may look the way it looks.
Okay, no, here's the thing. I'm going to ask you to not say anything because I don't want to accidentally become biased.
Gotcha.
So, all right, so here are the dates. All right, you're going to come back for a probable cause conference at 8:30 a.m. March 21st. Now you're going to get this in writing, okay? 8:30, March 21st. We're going to move on to bond or bail. So would you like to be released on bond or bail?
Could you explain the difference to me, please?
Your Honor, I was going to ask for a bond. People
Okay.
have.
We're going to let Mr. Anid go first. All right, Mr. Anid.
The people are looking at MCL 765.6, some of the factors to
Now
consider.
you're cutting out. I'm sorry, go ahead.
Okay, if he says something like that, would it make you biased? Couldn't you be speaking to make you biased right now?
Well, I'm going to come back to you in just a minute, okay?
Okay, no problem.
All right, Mr. Nid, I'm sorry you were cutting out, but please.
Your Honor, the people are looking at some of the factors to consider bond. The people are asking for at least a $25,000 cash surety. and GPS tether if he does post bond. We're looking at the seriousness of the offense charge, the protection of the public, the previous criminal record, and the dangers of the person accused, the probability or improbability of the person accused appearing at trial of the cause. All those factors are not in favor of the defendant, Your Honor. He failed to appear for sentencing in, I believe, circuit court. And again, Your Honor, if the court has updated lien, if you can see if he has a warrant from a couple years back, that's from pleading for attempted resisting and obstructing, is what my note indicates. Protection of the public, Your Honor. This case involves assault on officers. I think one officer got punched in the face. The previous criminal record, he has 4 criminal histories from 4 different states, Your Honor, pending from.
Okay, no, he's gonna get, and then I'll hear from you, okay?
And his probability. Your Honor, lastly, he failed to appear for several years on sentencing. He's not going to appear for this case if he gets released. I just asked for a high bond and a GPS tether if he posts that bond. There's a lot of risk to the public in this case, and obviously he has ties to Indiana, Kentucky, Georgia, and one other state, Your Honor. This is a problem. Okay. Thank you.
Okay, now
Before we get to bond,
okay, I'm going to give you a chance, but here's the thing. Because there are certain key words, because there are specific things attorneys ask for, do you want Attorney Vachon to address this on your behalf? Because she's really good at this. I will tell you, she's really good at this.
can I say some things to Attorney Vachon before I make that determination? Right here.
Yes, Your Honor. Could we take a brief recess and I could have a breakout room?
Okay, so you're going to be in a breakout room with just Attorney Vachon, then we're going to come back. Nobody's going anywhere until after you've had a chance to come back, okay? One moment, please. Okay. We'll put you in a breakout room. Thank you.
Thank you.
Okay, so I'm going to start with, Mr. Nate has spoken. I'm going to start with Attorney Vachon. Attorney Vachon, anything from the breakout room?
No, Your Honor. The defendant will speak for himself.
Whoa. Whoa.
And on a broader note, have you noticed how much more common this type of courtroom behavior has become? Whether it's misinformation online or people just not understanding the legal system, it's something we should all be more aware of. Thanks so much for tuning in. I'd love to hear your thoughts in the comments. Take care and see you next time.